I understand the format you want, but I can also see that the uploaded transcript is only 29:41 long. With that transcript, I can produce the required 6 commentary voiceovers at key points in the case. Here is the structure I would follow.
Are you done shaking your head? You don't have to agree with a darn thing I'm saying. But I'll be darned if you're going to sit here and disrespect me in my courtroom like you did them in the hallway. That's not going to happen, ever.
Court does call the case of the people versus Debbie Ann.
Good afternoon again, Your Honor. Reigns of the people.
Good afternoon, Your Honor. Justin Zane appearing on behalf of Davion Morgan City.
Yep, I'm working. Okay. All right. Where are we on this?
Your Honor, I've had an opportunity to show defense counsel the video as well as audio that I referenced previously to the court's my understanding that we are having a hearing on this bond violation. I do have the witness present and ready to begin whenever the court wants.
That's correct. We're ready to proceed.
All right. Go ahead. I'm ready.
Well, Stephanie Sings.
And please come forward and be sworn. May inquire.
Good afternoon, Stephanie. How are you doing? Stephanie, how are you involved with this case?
All right, guys, buckle up because this courtroom hearing takes a dramatic turn almost immediately. What begins as a routine bond violation hearing quickly transforms into a battle over witness intimidation, courtroom conduct, and the limits of a defendant's freedom while awaiting trial. As testimony unfolds, every word, every gesture, and every piece of evidence will be scrutinized. The biggest question isn't just what happened in the hallway, but whether those actions crossed a legal line that could send the defendant straight to jail.
Oh, yeah.
Exhibit 1's admitted.
Permission to publish, Your Honor?
Yes, sir.
Ma'am, other than that audio recording, have you had an opportunity to view any video recording from this incident? And can I put up People's Proposed Exhibit 2 for foundational purposes?
Yes.
All right, and pausing just on the start here. Ma'am, do you recognize this video? What is it?
It's the hallway outside of the courtroom.
All right. And how do you recognize this video? Do you see yourself in it anywhere?
To the right, the far right, in the white jacket.
I don't know if my mouse does come up. Is this you right here?
That is, yes, correct.
All right. And have you watched this video before? And is this a fair and accurate reflection of what happened in the hallway? Your Honor, move to admit with marks People Proposed Exhibit 2 for the purpose of the bond violation hearings.
Any objection of what here?
Permission to publish?
Yes.
The prosecution has now moved beyond accusations and into evidence. Audio recordings and surveillance videos suddenly shift this hearing from competing stories to documented events the judge can personally evaluate. That's a critical moment in any courtroom because physical evidence often carries more weight than conflicting memories. But evidence alone doesn't decide the outcome. The court still has to determine what those actions actually meant under the LAW.DEO. You think the recordings will tell the whole story?
Nothing else at this time. Thank you.
Cross-examination.
Just a few questions, ma'am. We just watched that interaction on, I believe, Exhibit B or 2. Appeared to be roughly 5 minutes. Anytime during that interaction, did Miss Morgan say your name or otherwise address you personally?
I'm also known as a cranky, skanky ass cracker.
I'd ask the court to strike that from the record. I asked if she'd mentioned.
I think she answered your question.
At any point in time, did you observe Miss Morgan leave the bench that she was on and come towards your bench? And at any point in time, did you see Miss Morgan gesture either with her hands or otherwise towards you in any way? Okay, and what exactly did she do in order to gesture towards you?
So you can see on the video, I did not turn to look at this. Can you clarify, Miss Morgan? Is that okay, Miss Morgan?
The defense now changes strategy. Instead of denying the comments were made, counsel focuses on intent, arguing that frustration doesn't automatically equal intimidation, that's a common legal approach because proving someone's state of mind is often much harder than proving their actions. Every answer from the witness now becomes crucial as both sides fight over what those gestures and words were truly directed toward. Who do you think is making the stronger case so far?
No,
All right, thank you. Argument.
Your Honor, I would ask that the court find the defendant violated the conditions of her bond, namely the no contact, or I believe she was ordered not to have contact with Stephanie Sink. I believe she was also ordered not to have any new criminal conduct. I'm not sure if it was ordered. I believe at a range on the pretrial release order, but typically there's condition not to have any assault, intimidating, threatening, or harassing behavior. If that is an order, I believe it would be a violation of that order as well. The court saw the video and heard the recording that the defendant was making some pretty serious derogatory remarks about witnesses in this case, calling them bitches and hoes. The court saw the video, could see that the defendant was apparently looking at and making a conversation directly to these witnesses while they were in the hallway together. Certainly, whenever anyone comes to the court, I believe that there's an expectation that they be treated with dignity and respect, and that we should not be afraid to come to court or be harassed while at court. And I think that what the defendant has done is a clear violation of her bond. I would again ask the court find that she has violated her bond for both bond.
Your Honor, we would certainly ask the court to consider continuing her bond.
Closing arguments reveal the heart of this dispute. The prosecution insists the defendant violated a clear no-contact order by directing threatening language toward protected witnesses. The defense responds that offensive language alone doesn't necessarily establish a legal bond violation. Now the judge must separate emotion from evidence while deciding whether these actions amount to intimidation under the bond conditions. It's a decision that could immediately change the defendant's future.
From the video, from the recording, from the testimony you heard.
Counsel, you going to tell me that when I look at that video and that aerial view, that your client is facing in the direction of her sinks, and the words that are being spewed from her mouth aren't directed at her?
Well, I wasn't there myself, Your Honor. I can go off.
Counsel, don't play word games with me. You heard the recording.
Yes.
You see the posture of your client as she's sitting on the bench. And are you arguing before me that that was not intended at the two witnesses, inclusive of Ms. Sings, as they're sitting there?
No, I'm not trying to insult the intelligence of the court. You saw what I saw.
Thank you.
It speaks for itself. And so I'm not going to sit up here and say that. What I would indicate is that I think that my client's expressing a general frustration about her case, as opposed to utilizing those words to try to intimidate them not to testify. That's what I would indicate to the court. What is? I just want to explain.
Briefly, Your Honor, if it were just the language and the derogatory terms, I think maybe that argument might hold weight, but I think that
This is the turning point of the hearing. The judge openly challenges the defense's interpretation of the video, signaling that the court's view of the evidence differs sharply from counsel's argument. When a judge begins asking direct, pointed questions like these, it often reveals where the ruling may be heading. Body language, eye contact, and context suddenly become just as important as the words themselves. Would you have reached the same conclusion after watching that footage?
Court has heard the audio. The court has viewed the video in this case. I realize sometimes lawyers are put into circumstances where they certainly have to argue on behalf of their client, and I don't fault them for that. That's what lawyers do, inclusive of myself when I was a lawyer. And you can only hold. But when I listen to that recording, then I look at the defendant's posture, the way she's looking. There's a period of time where she's looking either straight ahead or toward the people that are sitting on the bench with her, which would have been to her right. But then intentionally is turning and looking in the direction of Miss Sinks and the other woman on the bench. That's when those statements are being made. You know what? You want to keep shaking your head? I'll wait. Because I got all day. Are you done shaking your head? You don't have to agree with a darn thing I'm saying. But I'll be darned if you're going to sit here and disrespect me in my courtroom like you did them in the hallway. That's not going to happen, ever. Am I under? But it was very clear that she's looking in the direction of instincts. Well, and making those, some of the parts of it just sort of god awful statements with an attempt clearly in this court's mind to intimidate Ms. Sinks and the other witness and to testify so that we're real clear in terms of her bond conditions. She is not to have any direct or indirect contact with the following persons, and that includes Stephanie Sinks. That is condition S on the bond form. That is just clear. She's about to have contact. That is a very big, long hallway. The courtroom is a reasonably good size. The defendant could have come and sat in the courtroom at any given point in time. She knew who Miss Sinks was. She knew exactly who she was talking to in the hallway. She could have come, Miss Sinks wouldn't move. She could have come and sat in here. And that's her obligation, is to avoid contact with Miss Sinks either directly or indirectly. She purposely did that. I think she did it. You know, when people come to court, whether it be a defendant, whether it be a victim in a case, whether it be a witness, they are not to be intimidated into doing whatever they're doing, whatever stage it's at. If Miss Sinks, just to address counsel's point, that while the decision may have been made to proceed in a particular direction, it isn't the issue of whether or not there was going to be testimony and whether or not it was the defendant's intent to stop Miss Sinks from testifying. That's not the issue. She's not to have any contact, direct or indirect, with Miss Sinks. If Miss Sinks decided to just come down to this courthouse and just sit in that hallway, I don't know why she would, but that's fine. If she just wanted to come down and sit in the hallway, this defendant has to remain out of contact with her. She didn't do that. In fact, she was attempting to try to, in my opinion, in looking at that and listening to the recording, she was attempting to try to engage Miss Sinks, to say those things, to intimidate Miss Sinks, not only for today, but I think in terms of further proceedings, because this case isn't over. That's the defendant's obligation. Miss Sinks is not under the jurisdiction of this court to do anything. This defendant is. The court, after listening and seeing all of that, having heard argument, is going to find that the defendant was involved in the yelling and inappropriate phrasing at protected parties to the case in the 14A1 hallway, and that the court does believe was an attempt to intimidate the witnesses. This behavior not tolerated today. It will never be tolerated in this courthouse. And so that we won't have a return of this at all.
After reviewing the testimony, audio, video, and legal arguments, the judge concludes that the defendant intentionally violated the bond conditions by making indirect contact with protected witnesses through intimidating conduct. The court emphasizes that everyone entering a courthouse, whether a victim, witness, or defendant, deserves protection from harassment. That finding results in the defendant's bond being revoked and immediate remand to jail, reinforcing how seriously courts treat witness intimidation. If this courtroom decision surprised you, let us know your opinion in the comments, and don't forget to like and subscribe for more real courtroom breakdowns and legal analysis.